Lawsuits are now being filed in various countries including Spain, Poland, Italy and others. Today we will focus on the situation in Italy. For the following assessments, we contacted an Italian law firm specialising in commercial law and had them examine the general situation. The following points summarise their basic assessment and our own analysis. The insolvency of Myworld International AG from Austria and its affiliated companies Lyoness Europe AG and Lyconet International AG, both Swiss-based, has also left its mark in Italy. According to the Insolvency Administrator's Edict of the 1st of September 2025, the available assets are not sufficient to cover the claims. For ordinary creditors, this means that no repayments are likely to be expected from the insolvency proceedings themselves. Nevertheless, law firms and consumer protection associations are offering those affected the opportunity to take legal action in Italy. But how sensible is this, given the published capital structure of the companies there? There are 3 operating companies in Italy. Lyoness Italia S.r.l, with a share capital of €50,000, 100% owned by Lyoness Europe AG. Lyconet Italia S.r.l, with a share capital of €10,000, 100% owned by Lyconet International AG. And Myworld Italia S.r.l, with a share capital of €10,000, 100% owned by Myworld International AG. 2 of these 3 companies only have the minimal legal capital. Even Lyoness Italia, with €50,000 in capital, appears unlikely to be able to pay significant damages if hundreds or thousands of injured parties assert claims. Consumers in Italy can take legal action, for example, for breach of contract, recovery of payments or damages. This is legally permissible. Proceedings can also secure evidence or prepare judgments against members of the executive body. Economically, the problem remains according to the current state of the files. The equity capital of the Italian companies is too low. There are hardly any assets that can be seized. The parent companies in Austria and Switzerland are already insolvent, and according to the statement by the Insolvency Administrators dated the 1st of September 2025, do not have sufficient assets. Law firms therefore emphasise that lawsuits in Italy can only be part of the overall strategy. Parallel to this, the following are underway, among other things: criminal charges on suspicion of fraud, an example in Verona and also Vienna. Examination of liability claims against decision makers, including Hubert Friedel, based on current knowledge. Only if assets in Austria or abroad are traced in parallel is a possible payment realistic. Realistically, victims should not expect any repayments from the Italian companies at present. Their capital reserves are too small, and the insolvency of the parent companies deprives them of their basis. The possible outcomes of lawsuits would be that judgments in Italy that can later serve as a basis for taking action against board members or other companies, criminal consequences for those responsible, which may also indirectly strengthen the civil law position of the injured parties. Lawsuits in Italy have symbolic and strategic significance for injured parties, but based on the current state of the case files, they offer little prospect of repayment in the short term. The insolvency proceedings of the 1st of September 2025 clearly show that the assets are insufficient. Those who nevertheless decide to take legal action should do so with realistic expectations. It is less about immediate payments and more about documentation, determining liability and exerting legal pressure on those responsible.